Live from the SABC's Auckland Park studios, welcome to this week's Thursday edition of the Watchdog. My name is Vuyo Mvogo, and on the show tonight, the dramatic arrest of the defense lawyer in the Senzo Meyiwa case. What in the world was that all about, and how could it influence the public's perceptions of the case? We speak to a legal analyst.
When a member has stepped aside voluntarily, he or she should not make himself or herself available to be elected in positions.
The ANC leadership moves to tighten the step-aside rule, but concedes things could still be undone. Our panel weighs in.
There's no one who wants this finished more than I do.
And Chief Justice Raymond Zondo details to the SABC why he needed a postponement for the submission of the final part of the state capture inquiry report. All that and more in tonight's episode of The Watchdog, which starts right now. We'll start here. The defense lawyer in the Senzo Meyiwa murder trial says he has been arrested apparently on a fraudulent warrant of arrest. Advocate Malisela Tifo was detained following proceedings at the Pretoria High Court this afternoon. He allegedly failed to appear on a contempt of court matter. And in a dramatic turn of events, Tifo was handcuffed and taken to the High Court cells. It's alleged the warrant was issued in January. Tifo is representing 4 of the accused in Meyiwa's murder trial. The Bafana Bafana and Orlando Pirates goalkeeper was shot and killed in an alleged botched robbery at the home of Kelly Kumalo's mother's home at Falls Dolores in 2014. Before the adjournment, Tifo's instructing attorney Timothy Tobane addressed the court about threats they have been receiving as well as the imminent arrest. Speaking to SABC News, Tifo says his previous warrant of arrest was cancelled. Defense lawyer in the Senzo Meyiwa murder trial says he has been arrested on a fraudulent warrant of arrest. Advocate Malisela Tifo detained following proceedings this afternoon. Take a listen to what he told the SABC a little earlier.
As I said, that I've been arrested on the fraudulent warrant of arrest, which according to them it was obtained on the 27th of January this year. I've got the cancellation of warrant of arrest on the 28th of December last year with my attorney, Mr. Ngwato. So this one, I was never even aware that I was supposed to come to court. And insofar as allegation of trespassing, I was arrested in 2020, and that allegation of trespassing was withdrawn. I made the legal representations. It was withdrawn on the 21st of December 2020. So this arrest is nothing else, but it's all about the concern of Mr. Pekitele, the National Commissioner, about my involvement in this Senzo Meyiwa matter. They know what is going to come out for them. That's all I can say.
Wow. Tabiseng Dubazana is a director at Dubazana Attorneys and is going to help us make sense of that drama. And Tabiseng, good evening. Thanks very much for your time.
Thank you for having me, Vuyo.
Just before we get to the allegations, and the perceptions, I mean, people haven't run out of things to say about, that drama we saw unfolding earlier today. Just just what you made as you watched, that stuff unfold. What went through your mind, as an attorney?
Well, firstly, it was a shock as to, okay, what is happening? Because I'd been watching the trial as it unfolded, and just before the arrest and the matter being adjourned to the 30th of May, the instructing attorney stood up and said that during lunch, they had been receiving threats and there's an imminent arrest that's going to happen and all of these things. It seemed like, in fact, even the presiding officer was of the opinion that these are things that can be dealt with after they are done with examining the witness that was currently in the box, and then we can deal with all these allegations after. But it seemed so urgent for them that I think most of us were like, okay, maybe there's a little bit of drama happening here, not knowing what's going to happen. And as soon as the arrest happened, and we can call him the accused for now, Advocate Defo, was then showed that warrant of arrest, and then he was informed that he was failure to appear. I heard him keep asking the question, when was I supposed to appear? Which date? And the IO was responding, it's not my job to tell you when the date was. But when you look at Section 35 of the Constitution, I think he's not obliged, I agree. However, I think it would have been prudent, considering that you are now doing this arrest in front of the nation, basically, at least have the decency in terms of Section 35 of the Constitution to inform him of all his rights that are available to him, and considering that you are arresting him in front of his attorney as well and other legal representatives, there's more than enough evidence that show that you did not follow the procedure in terms of Section 35 by at least at minimum informing him of his rights. So that was just something very interesting to see.
Take us through this. Under normal circumstances, right? Say, indeed, yes, let's just say for a second, the warrant was legit, all right? And there's this lawyer in a court of law dealing with another matter. How are such things handled civilly under normal circumstances to avoid the drama we saw, but also the impression that the whole drama that unfolded then created, which we're going to talk about in a short while? But under normal circumstances, how are these things handled?
Well, under normal circumstances, what had happened when I was representing an accused person is that the investigating officer for another matter will come and inform us that once this matter has been concluded, they are arresting him on this matter. So they will allow for the proceedings to conclude for the day and have him arrested and then taken down to the cells, and then they escort him to wherever the matter is going to, the new matter is going to be held. So that is a normal process. That's what usually would happen in court if somebody has more than one pending matter against them. Usually it would be such instances where it is a warrant of arrest or it is an absolutely fresh case that the accused is now being informed of right then and there that he's being, or he or she is being arrested for. And then, the rest follows as such. But in this situation, we are dealing with a situation where the person being arrested is not actually an accused in the matter that was currently being heard. He is the attorney. So attorneys usually get threatened to be arrested for contempt of court because we tend to argue with the presiding officer if we feel like they're not hearing us. And then, because of tensions, they will threaten you that if you don't curb yourself, Mr. Bazana, you'll be held in contempt of court, which means you'll end up going to the cells at the bottom of the court. But this is very unprecedented. And it is very interesting to see how it was handled, considering that they are arresting not only a former police officer, but a current officer of the court in terms of his role as an advocate, and in such a dramatic fashion. It's usually not that dramatic. It was one person, one officer, and because it's the IO and his colleague, they arrest the accused and then they move away. It's never this hectic.
And add to that the fact that it would appear, certainly at face value, that his rights were violated. In other words, even the arrest wasn't done according to the book.
Yeah, so when we look at Section 35, there is old case law that is decided by the Constitutional Court that usually Section 35 applies to arrested persons, I beg your pardon. But with the case law that has come from the Constitutional Court, suspects are also treated in the same umbrella as arrested persons. So the rights that are enshrined in Section 35 apply to people who are suspected of having committed a crime. Now, having said that, when you are about to arrest an accused based on whatever the case may be, what usually happens is that the SABC, I beg your pardon, they take the accused person and then they only read them their rights once they hand them the rights sheet, which is a document written in red and all of that. And then only then do they inform them of their rights. So anything they would have said from the moment that they were arrested until the moment that they were issued with this rights sheet or rights form cannot be used against them. And this is the time where the police usually, or at least in my matters that I have dealt with, they usually solicit information from the accused, which would not be covered under the umbrella of admissible evidence when you look at that case that I've mentioned. And when you look at that alone, and also I want to go back to the case, Duduzane, when he was being arrested, or rather when he walked into court with shackles on his legs. So what we prevent as criminal attorneys is that the impression that is made on the presiding officer is to give the presiding officer an impression that the accused is coming as clean as they appear in front of you. You just have to judge and decide on the merits that are going to be presented to you. But now when the accused person walks in with shackles or dressed in the orange jumpsuit, it already gives the impression that this person is not untoward, is not clean as they appear. So this happening like this, it would be grounds for me, at least as defense attorney, to say it was an infringement of the Section 35 right, and also it's giving the court, because it was happening in court as the person who is defending accused persons, giving the court an impression that this person is not trustworthy because he's being arrested for contempt of court, which is failure to appear in a matter he was supposed to, and yet he knows what the rules of the court mean and what would happen should he be found guilty for contempt of court. That would be the reasons I would probably oppose this should the warrant have been non-fraudulent.
Now, all this happens after DEFO's instructing attorney Timothy Tobane addressed the court, talking about how they have been receiving threats, as well as this arrest that actually happened afterwards.
Yes. So what usually happens when an accused person is finding themselves in a position where they're being threatened by, let's say, members that are within the state's capacity, like witnesses or police officers, etc. What they ought to do under normal circumstances, of course, is then inform the IO of the matter so the IO can look into it. I think that's why the attorney was so insistent in saying that we don't need the state's assistance or protection, because the people that are threatening us come from the state. So if we go to them and ask them for help, they will be in a position to monitor our every move or every conversation, and thereby making us even more vulnerable. So I think it was just a matter of informing the court that, look, we are in trouble and we are intending on doing it the way that we want to do it to protect ourselves. But we are just letting the court know that should something of this sort or this imminent arrest and the threats are actually carried out, the court is aware of our concern. That is the situation, I believe, at least, that is happening currently.
Now, all of this, of course, it would seem that, well, let me not say it would seem, it definitely is going to play into the narrative that, powerful people, are manipulating this case. And I think Advocate, Mr. Tefu just, said as much in that clip we played earlier.
Yes, and he also did a whole 30-minute interview, I think it was, whereby he went into detail when he was still the watching brief in the Senzo Meyiwa case before he became the attorney on record for the accused persons. He indicated that there were two different cases that were being dealt with, and he name dropped, of course, the people that were interfering in the investigations of all these cases. He informed that there was one that was opened in January, I think, and then another one opened in October. And then he says that the parameters of both these cases were so different. In one, there is a conclusion from the investigating officers that there were 8 adults in the room and nobody in the house, I beg your pardon, and nobody left and nobody ran out or whatever the case may be, which means the suspect is one of the 8 persons that was in the house. And yet there's another one which indicates there was some kind of robbery, there were people running in and out and all of those things. So he wanted to figure out which of these two cases is the one that's actually going to go to court. I didn't manage to finish the entire interview, but when you look at what happened 4 months ago in that live interview versus what he continues to say and what he has already said today before the clip that you played before, it seems that his narrative might not be too far-fetched. I always say there's no smoke without fire, so there must have been something that he saw. And also his history as a police officer, he knows a lot of and knows better how the SAPS works versus us.
Mm-hmm. In fact, as we are speaking, and I was saying, my colleague, Criselda Lewis, has just forwarded me a tweet from Liranzo Temba, who is the Minister of Police's spokesperson. It reads, Minister of Police General Bheki confirms that he has requested a full report from the National Commissioner on the arrest of Advocate Tefu today at the Pretoria High Court, including the manner in which the arrest was conducted by SAPS. What do you make of that?
Well, that is a very interesting development. Perhaps one, he's going to say he didn't know or wasn't aware of the arrest. So perhaps that full investigation will reveal how the warrant was first issued and if it is indeed as fraudulent as Ndadetefo says. And then in order to make sure that should this matter, which I think it will, go on to be sued, that the state be sued by Advocate Tefu for wrongful arrest and then for what is this, criminal injuria and all of those things. They have a report whereby they can say that they had tried to, it is not within the Minister of Police ambit that this thing happened. They're trying to protect themselves before this matter actually goes to court for wrongful arrest where the state gets sued.
Wow, it's going to be interesting. Indeed. Thank you for your time and insights. And Tabiseng Dubazana was the director at Dubazana Attorneys. After the break, details of the ANC-NEC decision to shut the door on party leaders who are facing serious charges. Welcome back. This is the Watchdog. Former eThekwini Mayor Zandile Gumede and ANC MPL in Mpumalanga Mandla Msibi have escaped the amended step-aside resolution by a hair's breadth. The rule, which was recently tightened by the ANC-NEC, bars officials who are charged with serious crimes or offences from standing for positions. The ANC further says that those who have stepped aside will have their cases reviewed once a year or may request that this be done by structures they are part of. The party was briefing members of the media at its party's headquarters in Johannesburg this afternoon, following its two-day special NEC meeting that took place on the 24th and 25th. SABC politics reporter Natasha Piri filed this report.
The decision that those who are on step aside should not accept nominations. Is it retrospective? The NEC did not say so. So it means it affects the future, not the past. So we're going to apply it for the future. Because I mean, look at it this way. If there is no policy and a member of the ANC act in a particular way, and later a policy is taken, it might be unfair to go back.
ANC leaders like Zandile Gumede, who was recently elected as a chairperson of the eThekwini region, and Mandla Msibi, who was elected as the party's Mpumalanga treasurer, have narrowly escaped the tightened step-aside rule, as they are not retrospect and relate only to developments in future. Mashatile says the guidelines will continue to be reviewed by the branches of the party at its upcoming policy conference. Meanwhile, the MK Unity Conference will sit this weekend. The conference brings together both the Umkhonto weSizwe Military Veterans Association and the MK Council into one MK structure responsible for the welfare and well-being of ex-combatants.
I'm pleased to announce that conference has started today in East London, where members of Umkhonto weSizwe from throughout the country will gather there to ensure that they come with one committee, one constitution. The conference will be addressed this afternoon by the Deputy President, Comrade David Mabuza. We are hoping that if things go well, the President will go and close the conference on Saturday.
Meanwhile, NEC member Batabile Dlamini, who was found guilty of perjury last month by the Johannesburg High Court, is soon expected to present herself before the party's Integrity Commission to conclude her matter.
Comrade Bata is going to the Integrity Commission voluntarily. I've had a discussion with her, and we agreed that, look, when you are convicted with an option of a fine, essentially a matter should end there. But she's a public figure. There are people who think, this has brought an ANC into disrepute, etc. And she said to me, Comrade TG, I will go. I've been to the Integrity Commission 3 times, but I'm willing to go again. And I will abide by their decision, whatever they say I should do.
The party has taken a decision to disband the NEC of the ANC Women's League. The NEC based its decision on the fact that the leadership of the league's mandate expired 2 years ago, and it would be unconstitutional to allow it to continue to operate as a structure. Meanwhile, an ANC Women's League national task team will soon be established. The party's national officials and the National Working Committee will process the composition of the new task team. Natasha Phiri, SABC News, Johannesburg.
Well, in a year as big as this one, in which the ANC will be holding a selective conference, the matters that the NEC decided and on which journalists were briefed today are definitely going to be big, and they're going to be a cause for a lot of ructions within the party over the next few months. Now, to help us make sense of some of what we heard from that package by Natasha Phiri, I'm joined by Professors Lesiba Defu and Susan Boysons. Good evening to both of you, and thank you very much for your time.
Good evening.
Let me start with you, Professor Boyson. Did it come as a surprise to you that the ANC NEC took this decision with regard to the step-aside rule?
For you, I would not say it is a surprise, because we know indeed that the ANC depends on public perceptions of how well it is handling the so-called renewal and rebuilding of the organization, and acting against its own members and public representatives and emerging candidates and recently elected candidates. That is all very big parts of evidence that people will be looking at and voters will be looking at in the next election, to get evidence that the ANC is actually stepping away from being seriously corrupted and mismanaged party. And so the ANC really depends on that. So I'm not surprised that it's putting up this valiant attempt to see these orientations, commitments to rebuilding and renewing, to see those through. Although I am surprised that it is quite soft around the edges, in the fact that the resolution, and we heard Paul Mashatile repeat that resolution in a briefing today, being formulated in the language of should. These members should not be standing, etc. And I wonder what the legal interpretation of the word should would be. Organizational intent may be clear, but the word should, and they should not make themselves available, is not so clear. And besides that, it's made not to be retrospective, and it's made still to be subject to possible being revisited by the branches.
Professor Tefu, from your vantage point, did you see this coming on the part of the ANC-NEC?
What exactly, Will?
The decision to really tighten things on this step-aside rule.
Oh, yes, I saw it coming, and they had to, by the way, if indeed it is about saving one's skin. But is time on their side? I doubt. It's far too late in the hour for them really to come with mechanism that can save the ANC and return it to its yesteryear's glory. They know exactly where they lost the plot, by the way. They know. All these other things would not have been necessary had they just lived up to the spirit and the letter of the seminal document called Through the Eye of the Needle. If only they have lived up to the moral standards set by the Mbeki and Mandela team, both in government and in the ANC, certainly we wouldn't be where we are. They know where we're... Now, the other point, he says, Mashatile, MEC Mashatile, let me call him that, or Treasurer General in this context, he says to us, it is not retrospective. Two, the language in which it is couched, it is not peremptory, it is not compulsory. It is still dependent on the goodwill of the individual, to or not to live by what it is being advised. So they can continue to talk in platitudes, but you cannot fool them all the time. At one stage, they will see through. And the youth is restive. The nation has begun to vote with its feet. Maybe, yes, maybe, they must still redeem themselves. But as I maintain, it's far too late in the hour.
Take a listen to how, both of you, I wanted to take a listen to how Paul Mashatile countered as he was explaining to journalists the reasoning, behind this decision.
There are some, if you follow public discourse, who are saying you are making this decision because you want to prevent so and so. It's not true. It's not true, but it is a perception that is real out there, because it does mean that those who had an opportunity to stand now no longer have it if they are on step aside. So somebody can read it that way, that you are doing this to prevent so and so. We looked at it at the NEC, but we felt that this is about the ANC, not the individuals. Here we're protecting the organization, not ourselves. And once you put the interests of the ANC first, you have to make difficult decisions. That may affect your friends in the organization, your comrades that you like, but the ANC must come first. The public in South Africa is not happy that the ANC allows people who are charged to lead them. They are not happy. So we can choose to protect our friends or choose the people. And I think the NEC decided to choose the people.
So the ANC decided to choose the people. Now, we all know that, the reasoning behind this makes perfect sense. But Professor Boysen, we also know that it's not going to stop those people who know that their futures are going to be affected by this decision from challenging it along the very same lines, the Treasurer General of the ANC spoke about in response to a question that was being asked by a journalist.
Yes, indeed. It is a fine and pretty strong statement for the day, but immediately we see the soft edges developing and being fleshed out even by Paul Mashatile in addressing this media briefing. We see that, yes, we hear it must not be seen, in the words of the spokesperson, official, as action against a certain faction. But that faction, the opposing faction, one that is coincidentally, maybe not coincidentally, purposefully organized around fighting against the incumbents, fighting against the Cyril Ramaphosa faction, and they are the ones, not all of them, but more often than not, that come with some items of baggage, indictments or charges, allegations against them, and they tend to regroup around a camp opposing President Cyril Ramaphosa's camp, or those who say they are reforming and renewing. But that is very, very tenuous, because there will be fight back. We can already see that some people are saying that how come it will now be applied to some and not to others. And yes, even the Ramaphosa faction do have suspect tainted persons in their midst, and that will be given some proof that it is unambiguous, even-handed ruling, but it is most certain that it will be charged and challenged, I should say, and it will have a serious impact on the contest for the elections of the ANC towards the end of the year. And in a run-up to it, I cannot see that this is plain sailing, and it's a very soft, it's in a way a very weak statement that the ANC has brought out.
Professor Tefu, do you still maintain, even after that strong statement by Paul Mashatile, that it's probably late in the day now for this?
I maintain that, Will. The damage done runs far too deep. And they are not going to placate people by just coming up with platitudes that, by the way, are not new. What Paul is saying, there's nothing new about what he's saying. Not at all. The day might be different, the speaker might be different. But we have seen the country decline over the years with the platitudes of maintaining, improving the lot of the people. There are 2 points that I want to touch on, just to show you how far we have come with the ruling party. And I sympathize with those within the party who would still want to save it. I really do sympathize with them, because a limping ANC is not good for the country. For now, they are in charge. Up to well, I don't know. But to the extent that they are in charge, I wish them well. I wish they could retain the best brains among themselves. And such brains abound. There are a lot. But 2 points. They are disbanding the National Executive Committee of the Women's League. Why now? They are left with a few months to go to the conference. In 2007, the ANC Youth League was led by somebody who was 3 or 5 years over his limit, Fikile Mbazulwa. But deliberately and intentionally, they retained him because they needed him for that conference. Now, the other party might say, because you are stronger than us today, you are using this tactic to exclude us. But yesteryear, it was used otherwise. So, Vuyo, political expediency has tendency to catch up with the people that are playing into its space. That's the first point. The second point also has to do with those arrested, implicated, involved. You have your VBS, you have this. But how many ministers that you know of who were involved in Travelgate, who were convicted, who accepted and paid the fines and so on? They moved and got promoted and got up to that point. Why should you stop me, Vuyo, today when it is my turn to ascend to a higher office in the name of morality that we have always been flouting, at least with the help of nobody but ourselves? So I'm just citing this example to show you. Right now, if people were to be honest to themselves, how many ministers there who have criminal records against them? How many members of parliament? How many members of the legislatures who have criminal records? And they deliberately close an eye out of political expediency. And while they fall out of favor, they want to project themselves to be standing on a higher moral pedestal. People are much wiser today than they were 20, 30 years ago.
Of course, I mean, this decision could still be undone. I want to take a listen to what Mashatile had to say about the role that branches could, in the end, play in all of this, notwithstanding this decision taken by the NEC.
What the NEC decides on does not preclude the fact that branches must discuss. Because there is a policy conference, branches may as well raise this matter differently to the way the NEC has decided it. So we're not closing the gates or the doors. I think Lizaka had said that we never took this to the branches. We did. Yeah, no, we did. It was a big issue. So we did. Maybe the question should be, will you take this as well to the branches? The answer is yes. But the NEC has made the decision because the NEC is allowed to decide. But its decision can be reviewed because when we get to conference, when the members are there, they can say, yes, NEC, we hear you took this decision, but we want to reopen it, we want to discuss it. So I guess, Natasha, I've answered why not wait. We shouldn't wait. I think let the NEC discuss, take decisions. Those decisions will go to branches. As much as all the documents, the policy documents will go to branches, these will also go, the issue of step aside will also go to branches.
Professor Boyson, I was reminded when I listened to that part of Mr. Mashatile's explanations, I couldn't help but go back to what happened in the run-up to the Polokwane, the watershed Polokwane ANC conference, because ahead of that, you'll recall, the deputy president of the ANC at the time had been stripped of his powers with the concurrence of the ANC-NEC. And that policy conference at Tuks, which came before the Polokwane conference, took a decision that didn't belong to it. In other words, it was no place of that conference to review decisions that had been taken ahead of it. But because it was important for the ANC to hold that conference and to avoid a collapse, they then allowed things that were not supposed to be discussed and decided there to actually happen. And I foresee a similar situation over the next few months, in the run-up to this policy conference all the way to the December elective conference.
Yes, who can ever forget those heady days of 2005 when it was the rebellion from the conference floor, and we observed that firsthand. And I don't think that spirit of challenging the incumbent leaders in this party, in ANC, that spirit has not gone away. And we've seen little glimpses of it here and there in some of these nominations and challenges. And it could very well continue. It could very well be manifested again. We know and we see the evidence that the current leaders, in their imploring the leaders to renew and rebuild, etc., are not getting the full support, and they are being accused of being biased, of acting for their own faction. So it's a highly politicized environment, highly factionally politicized environment. And a decision like this that will specifically exclude some members to be standing, some members with serious aspirations and constituencies, is probably a harbinger of things to come, that they could that nothing can be taken for granted from what can happen on a conference floor can really go anywhere. And the branches will be doing their best. They will, if branches are determined to nominate implicated ones, that this ruling, I am pretty sure, will not stand in their way. So I think the fat lady has definitely not been singing yet.
Definitely. And Professor Dev, it's not just about, the aspirations that Professor Boyson is talking about. I mean, the ANC offers or gives people the kind of protection and advantages that they cannot get anywhere else. So they're going to fight tooth and nail. Those, of course, will be affected by this, by the tightening of this step-aside rule. So they're going to put up a very big fight.
We live in a society where public service or public servants earn more than corporate. Then it doesn't matter where. That society is doomed. When you live in a society where public servants earn more and public service is more attractive than corporate, that society is doomed. That's all I can say for now, Vuyo. The step-aside rule is being stepped aside.
Of course.
And it pains me because yesterday, in 1994, Vuyo, with great enthusiasm, we looked forward and we had hoped it would be different. And look where we are today. Sad. And it's the ANC that brought us here. And what is even more saddening to me, there are brilliant men and women, patriots, who have been kicked out, renounced and denounced, shafted outside of the organization. If they could come back, I wish they could. Because I know there are good men and women who have been kicked out, who have been shunned, who could make a difference. South Africa deserves better. If not, let the ANC get out of the fray and let another group of leaders or organization take over. And I'm one of those who say, even the ANC itself, in a reformed form, let it come back. But certainly, the current one doesn't deserve to lead this country. It has to be revised. It has to metamorphose. And it has to go back and take the good men and women who are worthy of the brand ANC to come back and lead this country or to lead the organization.
Special thanks to both of you, Professors Susan Boyson and Lesiba Defu, on the back of that announcement today by the ANC Treasurer General that the ANC-NEC decided at its meeting last weekend to tighten things around these step-aside rules to make it difficult, if not impossible, for people who have been charged or facing serious charges, criminal charges, to be elected or appointed to positions of power within the organization. We definitely haven't had the last of this matter as things are going to unfold, no doubt, over the next few days, weeks, and months, all the way leading up to the ANC's elective conference in December. Up next, Chief Justice Raymond Zondo explains why he needed postponements for the submission of that state capture report. That's coming up in a minute. Don't go away. Chief Justice Raymond Zondo has detailed to the SABC why he needed a postponement for his submission of the final part of the state capture inquiry report. He spoke earlier to our political editor, Mzwandile Mbeje.
It was supposed to have been concluded in 6 months, that is 2018. Before it started, you went to court because you realized that the work was going to be enormous. I think you've sought, 12 months?
Yeah, at that time, 12 or 18,
Yes,
I can't remember.
That was in 2018.
Yeah.
We're in 2022. As recently as yesterday, you went out to seek another extension. I'm just going to ask a very simple question. Don't you think, Chief Justice, it's better to seek a longer extension so that you just have enough time and conclude all of this? Because if you keep doing these smaller extensions, so to speak, it might affect the credibility of your work.
No, Mr. Mbeje, I think that it would be better to do it that way. But we haven't done it that way. But that's not because we chose to ask for less time when we knew we needed more time. I think maybe I'm to blame here. my assessment has not been as good as it should have been in terms of how much time we need. So I take responsibility for that. But maybe on another level, it's been because I want to finish as soon as possible. It's been 4 grueling years of the commission work. But we are at the tail end of it now. I was looking at the volumes of the report just before we came here, because yesterday morning, maybe about 3 o'clock or thereabout, my staff and I, 3 o'clock in the morning, my staff and I completed part 4 of the report. We were still working at that time. We completed part 4, and it was then electronically sent to the presidency. So it's with the presidency. Arrangements are being made for the day when the Secretary of the Commission will hand over hard copies to the Director General in the presidency. So that is how high the volumes are. Now, that's simply because the Commission had a lot of evidence on very important issues. And we have taken the view that we need to be thorough in terms of the analysis of evidence, because the findings we make affect people. They affect people's reputations and so on. And nobody must find that findings have been made against them, but they don't understand how we arrived at those findings. It needs to be quite clear how we came to those findings. And so we have taken the trouble to try and make sure that the evidence is analyzed properly and thoroughly. But to go back to your question, we are at the tail end. But I agree, it would have been easier to just ask for a long extension. But maybe the unintended advantage of the extensions we ask for is that they put pressure on us to try and finish.
Now that we are at the tail end, as you say, when do you think we should be concluded by? I know you've blamed yourself in terms of your judgment, but given that we are at the tail end, so what day, not necessarily date, but what time frame can you then give to say, you know what, by this time I'll be done?
Well, put it this way, I can simply say we have asked for 6 weeks. We are going to work very hard. We think we should finish with that within that 6 weeks. We accept, and I accept, that sometimes the assessment has not been accurate. But we are working very hard. I've just mentioned to you that part 4 of the report we completed at 3 o'clock. We work very hard. We work weekends. We work public holidays. I have a wonderful staff, team of people, also in the legal team, the investigation team, people who can work right around the clock because we all want to complete this task. As I've said before, there's no one who wants this finished more than I do.
Chief Justice Raymond Zondo explaining why he needed that extension. And that's our show for this evening. But we'll be back tomorrow evening at 8 o'clock sharp. Up next, it's The Globe with World News.